आज पढ़ने वाले हैं सुप्रीम कोर्ट और हाई कोर्ट्स के रिलेटेड आर्टिकल्स। इन्हें कौन कौन सी पावर्स है अपने कॉन्स्टिट्यूशंस की में। तो देखो, सुप्रीम कोर्ट्स के आर्टिकल 124 से 147 है, पार्ट 5 में आते हैं। ये अपन ने छोड़ दिए थे और 5 आर्टिकल्स और छोड़े थे। वो कौन से थे वो आप मेरे को बताएंगे। देखो, 124 बोलता है स्ट्रेंथ ऑफ जजेस। ओरिजिनली सुप्रीम कोर्ट के जज होते हैं एक तो सीजीआई प्लस 7, टोटल 8 होते हैं। 8% 32 जजेस हैं। मैक्सिमम पॉसिबल स्ट्रेंथ इन 34 जज, 1 सीजीआई प्लस 33 जजेस पॉसिबल है मैक्सिमम स्ट्रेंथ। Basic point is judiciary is an India is an integrated judiciary in independent. Supreme Court replaced the Feudal Court and the Judicial Committee of Privy Council after India gained independence. First sittings 28 Jan 1950. Feudal Court established on 1937 under the provisions of GOI Act 1935. Establishment and constitution of supreme appointments. Judges are appointed by President after consulting with existing Supreme Court and High Court judges. Tenure क्या है? Judges serve until the age of 65. Judges case क्या है? First judge case is SP Gupta case 1992. SC stated that the President must taken recommended from the CGI of India, which is not binding on the executive, granting the government significant discretion. Second Judge 1993, the Supreme Court introduced the collegium system, holding that consulting really meant concurrence. It added that it was not the CGI's individual opinion, but an institutional opinion found in the Constitution with two senior-most judges in Supreme Court, and the decision was binding on President. Third judge case आया 1998 Supreme Court on President's reference expanding the colleagues to a 5-member body comprising the CJ and 4 of his most colleagues. Decisions of colleagues was binding on presidents. Because Parliament replaced the colleague system by National Judiciary Appointment Commission (NJAC) through 99th Constitutional Amendment to provide recommendation to the President. Fourth judge case 1/19/2015 में Supreme Court declared 99 constitutional amendment as unconstitutional and null and void and replaced the NGAC with the collegium system. 2A. A judge may be writing under his hand address to the President resign his office. 2B. A judge to be removed in manner provided in clause 4. First female judge of Supreme Court Justice Fatima Bevi और फर्स्ट फीमेल चीफ जस्टिस ऑफ सुप्रीम कोर्ट नो वन टिल नाउ। इसका मतलब तो समझिए ना, नो वन टिल नाउ का मतलब अभी तक कोई भी नहीं है। अब देखो, नेक्स्ट क्वेश्चन की तरफ चलते हैं। क्वालिफिकेशंस हैज बीन 5 years of judges of high court or 2 or more such courts, has been at least 10 years an advocate of high court or more such courts, and is a distinguished justice in the opinion of the president, citizen of India. Removal of judges. Removal of a judges of Supreme Court on ground of misbehavior or incapacity. Removal method. Order of the President passed by an address of such houses of the Parliament. Special majority 2/3 of the present voting member removed. Parliament can create law to establish procedure for investigation and providing just misconduct or incapacity with under clause 4. Take away oath before the President. A former Supreme Court judge cannot practice law in any court or before any authority within territory of India. Article 120. Salaries determined by Parliament. Law or private salaries determined by President. Article 126. Appointment of acting Chief Justice. When the position of Chief Justice is vacant or if the Chief Justice is unable to perform their duty due to the absence or other reasons, the President appoints other judges from Supreme Court to carry out the responsibility of Chief Justice. Article 127. Appointment of ad hoc judges. The CGI of India can appoint a qualified High Court judge, a temporary Supreme Court when there are not enough judges to hold a session. She may have all the power, jurisdiction, privilege of Supreme Court judges during the peace period. Article 128. Attendance of retired judges at sitting on Supreme Court on advice of the President. Article 129. Supreme Court to be court of equal. It means that if a decision is preserved has a legal standard and it has the authority to punish for contempt of itself. Article 1. Seats of Supreme Court's constitutional decree. Delhi has a seat of Supreme Court. CJI want to declare any other seat of Supreme Court other than Delhi, it has to be take President's permissions. It refers to court authority to penalize action that disrespect or disobey its order. Article 31. Original jurisdiction of also execute. No other courts can deal. Supreme Court has the power to direct her seas rather than through the lower courts. Disputes between the CGOI and one more states, between GOI and any state or state one side or one or more state on other sides, between two or more states. Article 132. Applicate jurisdiction of Supreme Court by way of appeal from High Court in a certain case in constitutional matters. Applicate 133. Applicate jurisdiction of Supreme Court in civil matters properly marriage and divorce. Article 134 बोलता है applicate jurisdictions of Supreme Court is regard to criminals matters. Article 135. Jurisdiction and power of Federal Court under existing law to accessible by the Supreme Court. Article 136. Special leave to appeal by Supreme Court. Note privilege नहीं है. A person can approach Supreme Court if a no proper justice granted in lower courts. देखो ये हो गया 135 आर्टिकल्स. 36 माय मिस्टेक. 137. Review of judgment or order of by Supreme has power to review his own order. Article 130. Parliament by law can enlarge the jurisdiction of Supreme. Article 139. Supreme Court has the power to issue direction order or writs including writs in the nature of habeas corpus, mandamus, provision, quo warranto, scriptura, or any of them are the any process other than those martial clause 2 of an Article 32. Article 40. Ancillaries power of can support or help legislator to make law better. Article 141. Law declared by Supreme Court to be binding on all courts. Article 142. Enforcement of discharge and order of Supreme Court. Violation of separation of power not strict in India. In Bhopal case dated December 10, 1934, which was caused due to the Metallurgy Company Union. Supreme Court under Article 1 passed certain decrees. Has no power of judicial review to set aside government acts. Article 140. Power of President to consult Supreme Court. Advisory jurisdiction. President can go to Supreme Court if pre-constitutional matters. Supreme Court advice is mandatory but not binding on President. If matter of general importance, Court advice is not binding. देखो सुप्रीम कोर्ट के आर्टिकल्स याद करने की. सुप्रीम कोर्ट सैलरीज एसी ने सारस को सीट ऑफर का. देखो एडुटम रिलेटेड कोर्ट ऑफ दिल्ली ओरिजिनल एक्सेसरी बाइंडिंग कंप्लीटिंग एडवाइजरी. अब देखो हाई कोर्ट के तो इधर थे. एस्टेब्लिशमेंट हाई कोर्ट 215. अदर जज एज पार्लियामेंट डिसाइड अपॉइंटमेंट डन बाय द प्रेसिडेंट्स necessary colleagues resignation of presidents removal says as judge of Supreme Court provide misbehavior incapacities qualification no provision or distinct jurisdiction 10 years advocate of High Court he has held office for 10 years maximum age for High Court judges 62 है basic pointers है High Court first High Court Calcutta High Court 1862 later Bombay High Court 1860 Madras High Court 1860 first female judge of High Court Justice Anna Chandra Kerala first female Chief Justice of High Court Justice Leela Sethi of Himachal Pradesh. None of the high courts in India is 25. Application of certain provisions both in Supreme and High Judges Inquiry Act of 1960 or information governor are restriction paragraph being permanent restrictions from High Court judge from passing so in any court or being any authority in except the Supreme Court and the High Court articles salaries consolidate fund media pension consolidate fund necessary along these present rights and demand by government article After consultation of CA, appointment by Chief acting joint position of Chief Executive able to find details absent or the reason the President appointed the judge from the High Court or to act as a Chief Justice. Jurisdiction or election of this MLAs MPs High Court applicant rates governor does not need advice. Article 226 rate jurisdiction of High Court rather than wider than Supreme. High Court can issue the rights on legal plus fundamental rights. High Court may refuse to issue right, but Supreme Court cannot. How do you over all other courts? Article transfers of certain cases in High Court. Article 229 officers and servants and the expression of work by CGI of High Courts. देखो इधर एक साइड चीज छोड़ी इलाहाबाद हाई कोर्ट established in 1866. Civil and Judiciary Authority. Article 4 Rule of Court. She can act, set his own set of rules and operate as long as these rules approved by President and do not conflict with law made by the parliaments. This article lines management Supreme Court staff and their expression CGI's points the official staff service conditions set the rules for staff employment terms such as salaries and leaves expenses. These salaries Supreme Court operate costs including staff salary and pension are paid for consolidated fund of India. Article 140 interpretation. The Indian Constitution clarifies that when interpreting the Constitution, any significant legal question should also be considered. The GOI Act 1935, including its amendment order, may under Article 1935. The Indian Independence Act 1945 order issue under Article 1947. अब देखो ये आर्टिकल्स मैं जल्दी जल्दी पढ़ रहा हूँ क्योंकि देखो इनमें कोई समझ नहीं है सीधा फॉर्मूला है एक्सटेंशन ऑफ जुडिक्शन हाई टू यूनिटरी पावर ऑफ पार्लियामेंट अंडमान एंड निकोबार कलकत्ता हाई कोर्ट लक्षद्वीप कोची केरला हाई कोर्ट दादरा महाराष्ट्र हाई कोर्ट पौंडुचेरी माद्रा हाई कोर्ट तमिलनाडु छत्तीसगढ़ पंजाब हरियाणा हाई कोर्ट दो आर्टिकल 231 establishment of common high court for two or more states. 71st Constitution in Maharashtra, Goa have a common high court. Maharashtra, Arunachal, Nagaland, Mizoram, Assam have a common high court. Guwahati. Article 223 Appointment of district judges by governor after consulting High Court. Article 233 validation of appointment of a judgment etc. delivered by certain district judges. Article 234 Requirement of person and other than judges. Article 235 Indian Constitution grant High Court superior authority over subordinate court with its jurisdiction. Establishment High Court Court of Records Constitutional appointments application of certain power oath restrictions salary transfer Comptroller and Auditor General of India General of India 149 duties and power of Comptroller and Auditor General of India. देखो वो जो पांच की कह रहा था वो ये रहे 48, 49, 50 में it specifies the account of union and the state. 185 Auditor General Union account CAG submit report to Union account president whoever they are present in both the House of Parliament. State account CAG submit report to represent the state government who them is to be state legislature. अब 52 में क्या था ये आप ही बताएंगे. इसी के साथ हमारा ये हाई कोर्ट वाला भी खत्म होता है हाई कोर्ट और सुप्रीम कोर्ट का. देखो इसमें कुछ इतना होता तो है नहीं. अब मैं जल्दी से यूं कर दूंगा आपको तो वो भी गलत है. अब नेक्स्ट टॉपिक है जो कि लोकल सेल्फ गवर्नमेंट रूरल और अर्बन एवोल्यूशन ऑफ पंचायत राज इन कमेटी से होता. सबसे पहले 1957 में बलवंत राय मेहता कमेटी बनी थी. 3 टीयर पंचायती राज सिस्टम का इसने रिकमेंडेशन करा था. फिर राजस्थान फर्स्ट established पंचायत सिस्टम एट नागौर ऑन 2 अक्टूबर 1959 में. अशोक मेहता कमेटी 1977 में प्रपोज 2 टीयर पंचायत राज सिस्टम. जीवी की राव कमेटी 1985 में रिव्यू द वर्किंग ऑफ कॉन्स्टिट्यूशन इन रिलेशन टू द वर्किंग ऑफ द पंचायत एंड म्यूनिसिपालिटीज. एल.एम. सिंहदेव कमेटी 1986 में रिकमेंडेशन की पंचायत राज इंस्टीट्यूशन शुड बी कॉन्स्टिट्यूशनल और प्रोटेक्ट एंड प्रिजर्व. तुंगामन कमेटी 1988 में. गढ़ीगाल कमेटी 1980 में. 73rd अमेंडमेंट एक्ट 1922 में. कॉन्स्टिट्यूशनल अमेंडमेंट इंट्रोडक्शन थ्रू 73rd अमेंडमेंट एक्ट 1992 पार्ट 9 आर्टिकल 243 से 240 तक. शेड्यूल्ड है 11th और 12th पंचायत के लिए और 12th म्यूनिसिपल पार्टीज के लिए. 24 अप्रैल 1993 में इन्फोर्स हुआ. देन पीवी उस वक्त का पीएम नरसिम्हा पीवी नरसिम्हा राव थे। 24 अप्रैल 2010 पंचायती राज दिवस मनाया गया। 24 अप्रैल को आर्टिकल 243 डेफिनेशन देता है, ग्राम सभा मीन्स ए बॉडी कंसिस्टिंग ऑफ पर्सन रजिस्टर्ड इन द इलेक्टोरल रोल रिलेटिंग टू द विलेज कंपैरिजन विद द पंचायती एट द विलेज लेवल। डिस्ट्रिक्ट in a state, Gram Sabha body consists person registered in electoral roll within the area of panchayati at village level, intermediate level between village and district levels specified by governor, panchayat by any institution of self-government constituted under Article 243B for rural areas. Panchayati area, the territorial army area of panchayat populations as ascertained at least preceding census. A village specified by the governor, Article 243A, Gram Sabha may exercise such power and perform such function at the village level as the legislature of state may have law provided by the law state legislature. Article 243B constitutes there shall be constitution in every state panchayat at the village, intermediate and district level according with the provision of this part. Constitution of 3D panchayat is intermediate level not being constructed in a state having a population not exceeding 20 lakhs. 3 टियर होता है विलेज लेवल, ग्राम पंचायत, ग्राम सभा, ग्राम पंचायत, न्याय पंचायत, फिर पंचायत समिति, ब्लॉक लेवल, डिस्ट्रिक्ट लेवल पर जिला परिषद। Article 243 composition of all seats in the panchayat shall be filled by person chosen by direct election. Chairman person of panchayat village shall be elected as many legislature of state में by law provide. चेयरमैन होता है डिस्ट्रिक्ट लेवल, इंटरमीडिएट लेवल, विलेज लेवल, इलेक्टेड थ्रू डायरेक्ट इलेक्शंस, इलेक्टेड थ्रू डायरेक्ट इनडायरेक्ट इलेक्शंस। अब चलते हैं अगले आर्टिकल की तरफ, जो कि है आर्टिकल 243D, रिजर्वेशंस ऑफ सीट शैल बी रिजर्व फॉर द शेड्यूल्ड कास्ट शेड्यूल्ड ट्राइब्स इन एवरी पंचायत प्रोपोर्शन टू द टोटल नंबर ऑफ सीट टू बी फिल्ड बाय द डायरेक्ट इलेक्शन इन पंचायत। Reservation of seats, scheduled castes, scheduled tribes in proportion to their population. Article 243D, reservation of seats, not less than one third, including the numbers of beginning, the scheduled caste and scheduled tribe of total number of seats to fill by direct elimination shall be removed. Not less than one third of the total numbers of seats shall be reserved for one reservation on one third of the seats. Panchayat Raj of chairmen at all levels. Article 243 duration of panchayat etc. Even every panchayat unless sooner dissolved under any law for the time beginning in force shall continue for 5 years before the date appointed for its first meeting and no longer. Duration of panchayat a 5-year term unless dissolved earlier by applicable law. Election timeline before the end is panchayat before it ends held within 6 months of the term. If the remaining term is less than 6 months, election is not mandatory term or you can say panchayat form after early dissolution will serve only for the remainder of original term. No less than 26 months election not mandatory. President 24 more than 6 election and Punjab form will serve in a term. State government can dissolve dissolving power Jila Parishad. Article 243F disqualification of member shall be disqualified for being chosen as for being a member of Panchayat. Disqualification provision. Disqualification of member is also under law for time being is so imposed the state concern provide that no person shall be disqualified under 25 years attained the age of 21 years. Law made by state legislation can cause disqualification. Minimum age 20 years cannot be qualified if he is 25. Article 243F disqualification of members if he is so disqualified by or under the law made by the legislature of the state, high court, election dispute or MP and MLAs. State legislature has also power of panchayat. Disqualifications is decided by such authorities as determined by state legislature. Election कौन कराता है? State Selection Commission करवाता है. Article 243 Power, authority and responsibility of Panchayat. Legislature state may be the law and the Panchayat with such power authority of this sustainable them functioning sequence of constitution state is give power and responsibility to Panchayat to manage their own affairs and to carry them Growth in social welfare communities, water supply Acts 11 schedule of the Constitution, Article 243A, called embodied by the funds and panchayat, state can authorize the panchayat, legal conduct the operate tax deed, toll and act to establishment of funds of panchayat deposit. And proper financial management, Constitution of Article 243I, Constitution Financial Commission to review financial position, governor of state shall as soon as may be written on 1 year from the commencement of the Constitution, 73rd Amendment Act 99 after the expiration of the every 5th year. And to review the financial position of the panchayat to make a recommendation to the governor. Constitution of Finance Commission established by governor not binding under 73rd Constitution 1992 every 5 साल में होंगे. अब आर्टिकल 243J audit account of panchayat state will ensure financial transparency and accountable panchayat because they maintain proper accounts have been audited regularly. Article 243K election of the panchayat all elections of panchayat conducted by state election commission command the conduct of service under the office of state election government determined by governor. Article 243L application to union territory provision with Article 9 of the Constitution will deal with the panchayat shall be the union territory part modification and creations. Article 243M part not mainly to certain case. Article 243M excludes certain area like tribal regions, sub-north extension, panchayat system based within Indian government and local custom. However, the provision extends to Delhi. Nothing is this part shall apply to Nagaland, Nagaland, Mizoram. Panchayat system does not exceed hilly areas. Manipur districts exist here. Delhi is the only UT where the provision of panchayat are not applicable. Article 243 and contents of existing law and panchayat. Article 243 ensure a smooth transition of new panchayat system by allowing old laws to remain temporarily valid while the state make necessary changes to compile with update constitutional framework. आर्टिकल 243 ओ क्या बोलता है बार टू इंटरफेरेंस बाय बोथ कोर्ट्स इन इलेक्टोरल मैटर्स कोर्ट नॉट इंटरफेयर विद द defining panchayat or ascendancy. The panchayat election cannot be challenged solely; they can only be disputed through proper legal procedure after the elections. अब ये होगी याद करने की 243 ग्राम सभा बी कॉन्स्टिट्यूशन सी कंपोजिशन डी रिजर्वेशन ई डी पंचायत डिस्क्वालिफिकेशन पावर इम्पोज टैक्स कॉन्स्टिट्यूशन फाइनेंस ऑडिट इलेक्शन ऑफ पंचायत एप्लीकेशन ऑफ यूनियन पार्ट नॉट अप्लाई सर्टेन एरियाज कंडीशन एग्जिस्टेंस और बार टू इंटरफेरेंस बाय कोर्ट इन यूटीज एंड मॉडिफिकेशंस Peace Panchayat extension to Schedule Area Act 99. Provision to Parliament not applicable fifth schedule area. Parliament not exceed the provincial area such to certain modification. अब देखो बुरिया कमेटी रिकमेंडेशन करती है एब्सोल्यूट पावर टू ग्राम टू एंश्योर ट्राइबल सेल्फ रूल फॉर पीपल लिविंग इन शेड्यूल एरिया municipalities corporation urban local introduced through 74th constitution 19 part 9th of the under 12 financial subjects, first municipal corporation was set up in Madras in 1678. 1870, Lord Mayo presented a resolution for financial decentralization. Repo resolution of 1882, Magna Carta of local self-government is known as father of local self-government. Notified area committee, council and area protesters self-purpose three types: Vinnagar, Panchayat, traditional, municipal, small, municipal. The whole areas will do direct election and conducted by state election commissions. अब जो नेक्स्ट है वो है कॉन्स्टिट्यूशनल बॉडीज पढ़ने वाले हैं कॉन्स्टिट्यूशनल बॉडीज देखो बॉडीज तीन टाइप तो कॉन्स्टिट्यूशनल उन वो कॉन्स्टिट्यूशनल बॉडीज वो होती है जिनके अंदर कॉन्स्टिट्यूशंस के अंदर उनके एक स्पेसिफिक आर्टिकल्स स्टेचुरी वो होती है क्रिएटेड बाय लॉ बना के नॉन स्टेचुरी या एग्जीक्यूटिव वो होती है जो गवर्नमेंट अपने रेजुलेशन बना के दे देखो कॉन्स्टिट्यूशनल बॉडीज इतनी सारी है इलेक्शन कमीशन यूपीएससी स्टेट पब्लिक सर्विस कमीशन फाइनेंस कमीशन जीएसटी काउंसिल नेशनल कमीशन फॉर एससीज नेशनल कमीशन फॉर एसटी नेशनल कमीशन फॉर बीसी स्पेशल ऑफिसर फॉर लैंग्विस्टिक माइनॉरिटीज केग अटॉर्नी जनरल एंड एडवोकेट जनरल अपन इन सब के बारे में देख लिया हमने सबसे पहले देखते हैं इलेक्शन कमीशन ऑफ इंडिया के बारे आर्टिकल 320 324 से 329 पार्ट 15 permanent and independent bodies के not concerned with the election of panchayat and municipalities composition chief election commission plus two other election commission CEC appointed by president serve till the pleasure of president term 6 से 65 years की होनी चाहिए 6 साल तो रहेगा और 65 उसकी एज होनी चाहिए not presiding by constitutions qualification salary same as Supreme Court judge power and function administrative advisory and quasi judicial अब आते हैं इलेक्शन कमीशन ऑफ इंडिया पे ईसीआई इलेक्शन कमीशन ऑफ इंडिया देखो इसके बारे में थोड़ा और ओरिजिनली सिंगल मेंबर बॉडी है 61st कॉन्स्टिट्यूशनल अमेंडमेंट 1988 में वोटिंग एज डिक्रीज फ्रॉम 21st to 1890 electoral commission become a multi-membered body. First chief election commissioner Sukumar Sen. Article 3 superintendency direction control of election to be vested in election. Not person to be ineligible for inclusion in or to claim to be included in a special electoral roll or ground of religious, race, caste or sex. Article 326 Reputation of People's Act. Article 329 Power of Parliament to make provision with respect to elections to legislature. Article 320 Power of legislature of state to make provision with respect to election to such legislature. Article 329 Bar to interference by court in electoral matter. अब आते हैं यूपीएससी यूनियन पब्लिक सर्विस कमीशन आर्टिकल 315 से 250 पार्ट कौन सा है 14th Independent constitutional body. Present UPSC Chairman Preeti Sudan. Member composition and discrimination of president. Qualified to a member must held from government office for 10 years. Term 6 to 65 years. Recruitment All India Services. Central Services Group A and B. Known as watchdog of merit system in India. Removal by president if bankrupt, holding an office of profit, unfit misbehavior by president on recommendation of Supreme Court equality. Related articles declared 3 public certification for the Union State 316 article term for office of members Article 371 suspension of member of PCS Article 318 how to make regulation as to condition and service and member and of the commissions Article 319 क्या बोलते हैं provision has to holding an office by member of commission on ceasing to be such members Article 320 क्या बोलेगा Functions of PCS Article 321 Power of existing function of PCS Article 322 Expansions of PCS Article 323 Reports of PCS Staff Election Commission Article 315 से 323 Part 15 Independent Constitutional Body Member Composition and Discretion of President Qualification 1 to members must hold government office for 10 years term 6 से 62 years requirement state service removal by president if bankrupt holding unfit misbehavior by presidents वही सेम चीजें अब आते हैं फाइनेंस कमीशन आर्टिकल 280 है कोई जुडिशियल बॉडी होल्ड द समनिंग पावर ऑफ सिविल कोर्ट कंपोजिंग चेयरमैन प्लस फोर अदर मेंबर constituted by president every 5 year qualified chairman experience in public affairs chair the members are eligible for reappointment a judge of High Court qualified to appoint High Court judge, speaking knowledge of finance, account of government, economic exchange, financial matter, and related articles to 80 Finance Commission. Recommendation Finance it make recommendation to the President on the not proceed of taxes to state between central and state not binding on the President. 16th Finance Commission है चेयरमैन अरविंद पन्नारेगी फुल टाइम मेंबर है श्री अजय नारायण झा स्मृति अन्नी जॉर्ज मैथ्यू डॉक्टर मनोज पांडे पास्ट टाइम मेंबर डॉक्टर सौम्य कांति घोष फर्स्ट फाइनेंस कमीशन है 1951 में चेयरमैन के सी न्योय 14 फाइनेंस कमीशन वाई वी रेड्डी 15 फाइनेंस कमीशन एन के सिंह जीएसटी काउंसिल एडेड बाय 101st सीए 2016 न्यू आर्टिकल इंसर्टेड आर्टिकल 279 ए यूनियन रेवेन्यू सर्किट एक्ट एज एक्स ऑफिसर सेक्रेटरी ऑफ द काउंसिल कंपोजिशन क्या है जॉइंट फॉर्म ऑफ सेंटर एंड State chairmanship, union finance ministers, Nation, National Commission for SC and ST. Article 338 SC के लिए और 338A ST के लिए. Constitution consists chairman, vice president, chairperson plus all appointed by president. 89 Constitutional Amendment 2003 NSC Article 338 NST Article 338 Article 388 Special Officer for SC and ST 65th Constitution Special Officer to Commission 89th Constitutional Amendment 2003 National Commission for Backward Classes (VCS) established in 1993 originally a statutory body Sri Mandal Commission 1992 Supreme Court directed central government to constitute a permanent statutory body for backward classes. 1002 अमेंडमेंट करा 102 amendments Act 2000 confirm the constitutional status. Amendment insert a new article 388B in the Constitution. Special Officers of Linguistic Minorities का है 70 Constitutional Amendment 95 confirm a constitutional status. Inserted a new article 350B part Special Officers for Linguistic Minorities appointed by President. Article 350A says primary level education is a mother tongue. Computer and Auditor General Comptroller and Auditor General of India. Article 148 Head of the Auditor and Accountant Kit in 99 single member body appointed by President, removed by the same Component Auditor General known as Guardian of Public Purse. B.R. Ambedkar and most important officer under Government of India. First K. V. Nara Rao, Present K. Sanjay Maruti, 40 Component General of India. K. Duties and power of K. Former of accounts of the Union of the State. Auditor report submission of the President. Attorney General Article says law officer in a country appointed by president not fixed by constitution qualifying. अब ये देखो ये मैंने पहले पढ़ा रखा है इसलिए मैं एडवोकेट जनरल भी पढ़ा दिया था मैंने. Term removed by general qualified court judge given as government to legal advice to him by the government. अब पढ़ते हैं statutory body created through law. National Human Rights Commission established 1993 under Protection of Human Rights 1993. Chairman retired and CGI Judge of Supreme Court plus 5 full-time member appointed by President recommendation 6-member committee. Not eligible for reappointment as central state government. Tenure 370. Involved of human rights in the country. Present Chairman Vijay Bharati Sahani. State Human Rights Commissions का setup 1990 and Protection Act of 1993. Chairman retired judge of plus 5 full-time members. Appointed by government receive member involved by President. Tenure 3 से 70 साल. Chief Information Commissioner हिलाल समारिया है अभी. सेटअप हुआ था 2005 में. राइट ऑफ इंफॉर्मेशन एक्ट 2005 के अंदर चीफ इंफॉर्मेशनल कमिश्नर है उसके अंदर आता है आरटीआई. नॉट एलिजिबल रीअपॉइंटमेंट अंडर सेंट्रल स्टेट गवर्नमेंट. और सेंट्रल विजिलेंस कमीशन है सेटअप 19 एग्जीक्यूटिव एस्टेब्लिश व रिकमेंड बाय सत्यनारायण कमेटी. स्टेचुरी स्टेटस 2003 में मिला. ओरिजिनल कॉन्स्टिट्यूशन और स्टेचुरी अपॉइंटमेंट एंड रिमूवल प्रेसिडेंट. सीबीआई भी एक एग्जीक्यूटिव बॉडी है. I means executive body है set up in 90 by executive resolution. Desires power from Delhi Police Establishment Act 1946. National Institution of Transfer नीति आयोग बना executive body है. 1 जून 2015 replacing Planning Commission. Chairman PM. Governor Council CM of all states plus Lieutenant Governor of UTs. Appointed by PM. CEO BVR Subramaniam. Vice President Subramanian के बारे provide recommendation to the government. Law Commission Executive Body. First Law Commission 1995. First Law Commission MC Stable Post Independence. First Law Commission Macaulay Independence. 1834 Law Commission, Lokpal and Lok Yukti Statutory Body, Lokpal and Lok Yukti Article Act 2013, Lokpal for Center, Lok Yukti for State. लोकपाल में चेयरमैन प्लस 8 मैक्सिमम अदर मेंबर्स, रिटायर्ड जजेस और सीजीआई और सुप्रीम कोर्ट के जजेस, 50% जुडिशियल मेंबर्स, 50% एससी एसटी और माइनॉरिटी वुमेन्स मेंबर। करंट चेयरपर्सन है अजय मैकराव कानविलकर, फर्स्ट चेयरमैन थे पिनेक चंद्र घोष। इसी के साथ अपनी स्टेचुरी बॉडी वाला भी पार्ट खत्म होता है। अब नेक्स्ट है इम्पोर्टेंट एक्ट historical value. Queen Elizabeth granted East India Company charter license on December 31, 16th. Charter gave the company the exclusive right to trade with India. Centralized bringing things to one central place or under unified control started from 1773. कंपनी रूल 1773 से 85। सबसे पहला आया रेगुलेटिंग एक्ट 1773। द गवर्नर ऑफ बंगाल कन्वर्टेड टू गवर्नर जनरल ऑफ बंगाल, मोर पावर गिवन। क्रिएशन ऑफ एग्जीक्यूटिव काउंसिल ऑफ 4 मेंबर टू असिस्ट गवर्नर जनरल। फर्स्ट गवर्नर जनरल वॉरेन हेस्टिंग था। बॉम्बे एंड मद्रास प्रेसिडेंसी अंडर सबऑर्डिनेट टू बंगाल। एस्टेब्लिशमेंट सुप्रीम कोर्ट एट कलकत्ता। फर्स्ट चीफ जस्टिस प्लस 3 अदर सुप्रीम कोर्ट was established 26 जनवरी 19 Inaugural session 28 Jan 1950. Governor General of Bengal, Governor of Bombay, Governor of Madras. It provided the survey taking bribe from the peasants from India Court of Directors to manage commercial functions, report on its revenue and military affairs. Voting as last Governor of Bengal, First Governor of Bengal, First Chief Justice of Supreme Court, Kolkata, pre-independence, Ijwin Impli, First Chief Justice of India, post-Indian Justice Harilal Kanhaiya, amending Act 1780 is known for Act of Settlement that rectified the defects of regulating Act 76, exhibited the Governor General and Council from the jurisdictions of Supreme Court. Pitt's Indian Act 1784 differentiating commercial taken care by court of direction and administrative function of company. It created the Board of Control to manage administrative affairs. Delhi control started from there. It was called an alpha loopy system, short mediated through between Parliament and company's director. For the first time, company's territories in India was called a British provision in India. Dual control half loop system, commercial function, CODI, administrative British Parliament. Pitt's India Act was named after William Pitt the Younger. Charter Act of 1793 extended the trade monopoly of the company in India for another period of 2 years. Commander-in-Chief was not be a member of the Government General Council unless he was so appointed. Member of Board of Control and staff were to paid out of the Indian revenue. It abolished the trade monopoly of the companies in India and continued the monopoly of the country over trade in tea and trade with China. It asserted the sovereignty of the Britain Crown over the company's territory in India. It allowed Christian missionaries community to promote Christianity. Rupees 1 lakh was allotted to be spent on Indian education. It authorized the local government in India to impose taxes on persons for not doing so. फिर आया आरटी चार्टर एक्ट also known as सेंट हिलालाल एक्ट. The Governor General converted to Governor General of India. First, William Bentinck deprived the Governor of Bombay and Madras of their legislative power. It ended activity of East India Company as a commercial body, became purely administrative body. Lowest monopoly trade with China. It provided for establishment law commission of India is consolidated and codified India law. It attempted to introduce a system of opening competition for selections of civil servants. A law member to be Governor Executive Council. पहला हुआ था. First Law Commission of India was Thomas Babington Macaulay. Indian Penal Code was introduced in 1860. First Indian to qualify civil service Satyendra Nath Tagore 1863. Charter Act of 1853 separated legislature and administrative function of the government general officials. Under it, there was the addition of 6 new members of council as legislative council. It introduced open competition for civil servants. It extends the company rule in India territory, but period is not specified. Introduced local representation in India Legislative Council. One of the 6 of the government general council were appointed by the local government of Madras, Bombay, Bengal, and Agra. It is also known as Queen Proclamation. The act, also known as for good government of India, was abolished the East India transfer the power of government, territory, and revenue British Crown. It changed the designation governor year that Viceroy of India, Lord Canning, became first Viceroy of India. In this ended the system of dual government by abolishing the border control and court of directors. It created a new official Secretary of State for India, which was stated by 15 members Council of India with complete authority and control over Indian administration. Peel Commission 1850 after 1857 religious reform and British government accept that recommendation and redesign the Indian military. Indian Council Act 1861 associating Indian with law-making process in 1862, Viceroy nominated Raja of Banaras, Maharaja of Patiala, Sri Dinadar Rao to Legislative Council. It ended the procedure discussing central level restoring the legislative power of the Bombay and Madras Presidency. It also provided the establishment of new legislative council of Bengal, Northwestern Provision and Punjab. Recognition of portfolio system introduced by Lord Canning in 1859, it empowered the rights to issue ordinance without the conveyance of the legislature during the emergency. The life of such ordinance was 6 months. Indian Council Act 1909. The act is also known as Morley-Minto Reform. Lord Morley was the Secretary of the State for India and Lord Minto was the Viceroy of India. It is considered increase the size of Legislative Council both central for the known number of members in the central legislative in 16 to 16 members, official majority central legislative council and non-official majority provincial legislative council. Members were allowed to ask supplementary questions, move resolution on budget and so on. It provides for the Association of India with Executive Council of Viceroy and Governor. Sityan was the first Indian to join and was later appointed as a law member. It introduced separate electoral for Muslims system of communal representation. Muslim members were elected by Muslim voter and Lord Minto, father of communal. Indian Government of India Act 19. This act is also known as Montez-Chelmsford Reform. Montez was the Secretary of State for India and Lord Chelmsford was the Viceroy of India. Features classification of all subject of admission into two categories, namely the central subject and the provisional subject. There was the further divide into two, transferred and reserved. Hierarchy introduced in these provisions. Governor General was not responsible subject to public health, education, local self-government, agriculture, etc. Sub-policies, administration of justice, prison, land revenue, finance. Governor General was responsible. It reduced bicameralism and directly in the company for the first time for consisting of an upper council of state and lower house legislative assembly. It required that the three of the six members of the vice executive council other than commander-in-chief were to be Indian. It was created a new office above the house for Indian to London, transfer him to some of the function. Public service commerce established and central public service was set up in 1964, equipping civil servant. It separated provisional budget for central budget, extended the system of separate electorate for six Indian, Christian, Anglo-Indians and Europeans. Government of India Act 1935 imposed 1st January. It abolished Dihaj in provision and introduced Dihaj at the center. It provided for the establishment of all India Federation considering provision and plans listed as unit. Slain thus the West Bengal, Bombay, Madras, the number of states scheduled caste, women's labor extended developed franchise 14% of overall birth had right to vote. Reserve Bank of India was established. Federal Public Service Commission was established. Federal Court was set up in 1970. Burma now Myanmar was separate from India. It divided the power between center and unit. Released federal center for 59 units, provisionally for 54 and released for both. Residual power were given to the Viceroy Governor General. It abolished the council of 15 members. Indian independence on February 2, 1990, British Prime Minister claimed it declared the British rule in India would end by June 19. Power would be transferred to responsible Indian hands. It signed the British rule in India and declared India as an independent and sovereign state for August 1591. And certain on two independent dominant India and Pakistan was the right to secede from the British command was done. It abolished office vice and provided governor was appointed by the king on advice of Dominica. 7 of his function secretary for state, Commonwealth. It proclaimed the lapse of Britain paramountcy over the Indian princely state and treaty legitimate tribal area from August 15, 1946. It granted freedom to Indian princely state to join the Union. or Pakistan to remain. The Governor General would have full power to assist any bill in the Time of Majesty. It distinguished the Governor General of India and Provincial Governor as a constitutional nominal head of the state. It dropped the title of Empire of India from royal titles of the King of England. It discontinued the appointment of civil servants and execution of posts for Secretary of State. At the stroke of midnight 1459, the rule came to an end and power was transferred to the new independent Dominion of India. And the first Governor of India, Mountbatten, and the first and last Indian Governor was C. Rajagopalachari. इसी के साथ अपनी पॉलिटी होती खत्म।